to be on time, so I'm going to get us started here. I want to say good morning and thank you so much for joining us today. We are very happy to be able to connect with everyone during these challenging times. And our goal is to be able to help address any questions that you guys have, and we will do our best to answer them. Everyone is on mute, just so you know. We are recording this session so that we can share it with those that could not attend this morning. And we will be using the chat feature for any sort of questions that you have. So please just type those into the chat box. And we're first going to address the questions that we got ahead of time. And then Laura is going to be reading out the question to everyone. And then Scott will answer those for us. And we're going to try to limit this to an hour just because I know we could probably have Scott online all day. But we know that he's a busy guy and we don't want to keep him that long. So I'm going to turn it over to Laura Sellards and she will take over here. Thanks,
Great.
Everyone.
Thank you, Scott, for joining us. We're super appreciative to have your guidance and opinion on these questions. And thanks to everyone else who is on the call today. So our first question is it necessary to disclose to potential buyers if an occupant of the property has had COVID-19 and when?
Well, okay, so perfect. Thank you. First of all, I appreciate you guys' time and inviting me to participate. I obviously, I wish I was up there in your office, face-to-face with all of you and enjoying your beautiful community, but not meant to be right now. But hopefully at some point later this year and certainly going forward, we'll all have that opportunity again. And I'm sure we'll get back there. So thanks for dealing with me virtually at this point. To answer the question, is it necessary to disclose? I'm going to answer that in two ways, I guess. I'm assuming the first way about this is that in the event that a seller has or has recently had COVID and they're listing their property, clearly you would be declining showings, you would be disclosing that, you would not be holding active showings at all. And so I'm assuming that the question isn't for the first scenario, because absolutely, if there's been the presence of COVID among family members, among occupants of a household, then I would, the property should be withdrawn and, sort of fully sanitized and all reasonable 14-day quarantine kind of time periods. All of that needs to go by before you are relisting or allowing anybody to enter the property. So that's the pre-closing side or the marketing side of things. If you're talking about then if somebody has had COVID and is it a traditional seller's property disclosure? And because at some point in time over the last theoretically, 6, 8, 10 weeks since this disease has really flared up, the seller had it, but they've recovered and so on. I would say that it still is. It certainly isn't a traditional property disclosure in the sense that it doesn't go to an adverse material fact regarding the condition of the property like traditional property disclosures go. And in fact, I would say that it probably, in a traditional standpoint, is more analogous to what I would describe as a property stigmatization. In other words, we know that issues related to the disclosure of AIDS or a seller having died in the property or a murder, suicides, those kinds of traditional stigmatizations are mandatory non-disclosures. And so this is a medical issue, it's a disease, but I would say that, this sort of traditional mantra of disclose, disclose, disclose makes the most sense, particularly in the case of this. This is such a fluid and unique kind of situation. And I understand the sort of fair housing or ADA or medical implications of the fact that it's a medical condition. But if I'm a listing agent and my seller in the last 8 weeks or 10 weeks or whatever has had and recovered from COVID, I would probably be disclosing that out of abundance of caution, or encouraging your sellers to disclose that out of an abundance of caution. Again, just because of the incredibly unique and fluid nature of this specific disease. And so is it mandatory? I guess I would say probably not, because the seller's property disclosure and the seller's disclosure obligation goes to adverse material facts related to the condition of the property. But abundance of caution, I would encourage your sellers to disclose. I think most reasonable buyers, assuming that you're outside of any sort of normal or medically suggested quarantine periods, and the house has been fully sanitized, disinfected, most buyers aren't going to not close on a property because the sellers at some point in time have had and have recovered from COVID. But disclosure is always best. So
on that note, I'm just going to pull a question in that we had last week regarding HIPAA.
Yep.
And your take on our role as it relates to HIPAA.
Well, I mean, again, we're in an uncertain time, or we're in a very unique time, I guess is the best way to say it. So traditional, I mean, HIPAA is what it is, and it certainly applies to from a privacy and non-disclosure standpoint. I think it certainly applies to everything, but this is not you disclosing your seller's prior COVID condition. This is your seller disclosing their prior COVID condition. So to the extent that they want to sort of waive any HIPAA privacy limitations or expectations, as like I say, I would encourage them to do, then I would tell you that that's their disclosure. So I don't think the HIPAA thing applies. I mean, let me be clear. I wouldn't, as a listing broker, be unilaterally without your seller's express authorization disclosing that. But I'll draw the same analogy to the stigmatization stuff. You as a broker in Colorado are not allowed to disclose property stigmatizations without your seller's informed written consent. And so, and that includes the sort of, spectrum of things that we've discussed, including medical conditions or death by medical conditions or death in the home or all of those things. But it doesn't prevent your sellers from, with their informed written consent, from disclosing or authorizing you expressly to disclose. So I don't think the HIPAA concern is a problem unless you potentially would be unilaterally without your client's authorization. And I would get it in writing. I would still achieve the informed written consent, but it would still be coming from them effectively. So does that make sense?
Yep, that does. Thank you. Okay, so the next question sent in is, should something be posted at listings in regards to measures taken regarding cleaning, PPE, etc.? And then the second part to that question is, who is liable, if anyone, if someone gets sick? Listing broker, buyer broker, none, both?
Okay. Well, so in terms of posting, so I'll give you, I'm just going to get to this, and you guys are very organized that you have all these pre-questions. So I'll go to my, where I was going to end up a little bit later, and I'll just let you guys know that I'm just wrapping up, just before I got on this call, actually, I was going through and doing a little bit of redlining on a buyer and seller advisory that CAR is going to push out here within the next, well, I'll say before the end of the day Friday, and probably sooner than that even. And so there's two different advisories, and they're basically just a kind of a page or page and a half document that they're not liability shifting documents. So let me be clear about this. I know a lot of brokerage firms have gone to your legal counsel and engaged attorneys appropriately to prepare indemnification, waiver documents, basically contracts that shift liability from one party to another. And so in concern over the liability question, a brokerage firm could go out, and if you've got a buyer or seller and you give them this document, have them sign it, and essentially says, if you get COVID based on viewing property, or if you're a seller and you get COVID because buyers come in that I've scheduled to come and see your property, you're going to waive any claims against me in advance, or you're going to indemnify me if I get sued. There's a whole spectrum of things that might be prepared by attorneys. If you guys are using those that are prepared by attorneys, then that's between you and your attorney, and I'll leave that there. I guess that time will tell. We'll know over the next several years after this has been litigated how impactful and whether those liability shifting documents that maybe are being used right now, whether they are even upheld or acknowledged by a court when somebody tries to exert those as a defense. So I'm not sure whether they're effective or not. This is, again, a bit of a novel time, no pun intended. But if you're using those, you're using those. So what we've prepared, or what I'm wrapping up here, are just advisories. So there's no shift of liability. They're not legal contracts in the sense that they create or waive any legal obligations between two parties. But one would be given to a buyer and one would be given to a seller to sign and acknowledge their receipt. And it basically walks a seller through some of the concerns that they might have in terms of listing their property right now and exposing it to potential showings and various buyers that may be coming through, and advises them with regard to some precautions that they want to take between cleaning, or between showings for cleaning, disinfection, written instructions for buyers and buyers agents to be wearing masks, limiting the number of buyers that are showing. And then there's a buyer advisory that similarly, advises a buyer who's going to be looking at multiple properties to take certain precautions, make sure their hands are clean, obviously not see or go view property for showings if they've been sick, all of those things. And so 2 different documents, I'll have them out in the next, I'm probably 24 hours. And those could be used to give to your clients to essentially acknowledge that, hey, this is a unique time. And if you're a seller, you need to be thinking about these things. If you're a buyer, you need to be thinking about these things. And, not going to shift liability away from you or your brokerage firm, but it is something that would address kind of the concerns related to, wearing masks and not touching a lot of surfaces, not opening every cabinet and, doing all this stuff. And so I think you'll have those shortly, and that might address some of the concerns. In terms of liability, my thoughts are this: we don't exactly know. I mean, ultimately, I think we'll find out. It's going to be a few years before we ever figure this out, because whether or not a broker had liability is going to be a claim that's going to be made by whoever gets sick. And I do think that there could be a colorable claim there. In other words, to the extent that you have a seller who has been sick, and they open up their house to a series of buyers that might come through during the course of a day, and then seller realizes that they were ill. They then have to notify all these buyers that came through the house. Those buyers might well try and sort of color a claim that the seller invited them into a home through scheduling a showing and essentially contaminated them in some respect. And so that's a legitimate concern. And similarly, imagine you take out a buyer's agent, you take out your buyers, and you look at 6 different properties in an afternoon, and then the next day your buyer tells you, oh, I've become sick and I've been diagnosed. Well, now you've got potentially even worse, 6 or however many different sellers that you've seen the property. And particularly if they're occupants of the home, now you're going back to those sellers and saying, hey, my buyers exposed your house potentially to COVID. And to the extent that occurs, then, imagine a seller that says, well, great, thanks for telling me. I'm going to move out for, a week with my family into a hotel somewhere. And I'm going to have a professional cleaning company come in and decontaminate, or, an environmental hazard company decontaminate, and I'm going to send you the bill. Well, if you're a broker, if you're a buyer in that case, what do you say? I'm not going to pay it. And that's where that's going to be the inception of litigation, that ultimately there's going to be a judge somewhere, sometime in the state of Colorado and throughout the United States, I'm certain, that's going to determine who was liable and what created that liability. So, that's a question that can only be answered, I'm guessing, probably years down the line, which just leads to the importance of being super, super cautious, being very judicious in terms of your showings, really qualifying buyers, more than ever. I normally tell brokers to really qualify buyers for the purposes of not wasting your time running around and showing them stuff that you're losing your valuable time on. But in this case, you're qualifying buyers to make sure that they're super legitimate, that they're healthy, and that they're really focused in on certain property types or categories or price points or whatever that is. And that's for everybody's protection. So. Did that answer it?
I think so. Thank you. So our next question is, and I think you've talked about this in your legal bites, if a seller refuses to show a broker or buyer who has had the virus, could this be considered discrimination or a violation of fair housing?
Well, I mean, maybe. Again, I guess ultimately time will tell. This is a totally unique situation, right? And there's no aspect of this that really fits into any of the sort of preconceived boxes that we can have certainty with. And so my guess is probably not. I mean, to the extent that somebody is discriminating against somebody based on a medical condition, or their, quote unquote disability, their health, I think it could potentially present a claim if that buyer were to file a fair housing complaint with the Colorado Civil Rights Division or whatever the appropriate, authority is. The question then becomes what happens in that case is that they open an investigation, and the seller is going to have a chance to say, well, I'm 85 years old and I'm worried about it. I have a variety of pre-existing conditions that may invoke concerns, any of those things. And so now where does that go with a fair housing administrator? I just don't know. I think there's going to be an awful lot of reasonable forgiveness, I guess, in this potential case. But could it be a fair housing violation? Sure. Is it very likely? I'm guessing not. If a seller is really concerned, if they have a pre-existing condition, if they're of advanced age, if they're super concerned about COVID, then take the listing off the market. Withdraw the listing until there's a point in time where the seller can now, not have the same concerns that they would be having. I think that's probably the best advice if they're really concerned about it. So anyhow, all bets are kind of off. I do think it probably cuts, at least in my perspective, in favor of a seller who is reasonably concerned about contracting the disease and denies a showing to somebody who certainly has. I mean, that makes obviously there's no issues there, but if they have had, and then you get into questions about the spectrum of time. I mean, did they have it 6 months ago? They fully recovered. There's, whatever. Anyhow, I don't know. I wouldn't be concerned about fair housing specifically in this case as much as I would be in other normal cases, but I would be telling you guys as listing brokers that it probably falls within your standard of care to advise a seller fully that if they have concerns that are unique or they don't want to be providing access generally to people at this time, then withdraw the property. Come back at another time when it makes more sense for them to list and actively show.
So just to follow up on that, and I know it's probably too early, is this something that would fall under an E&O claim?
Yeah, good question. I don't know. Sorry.
I thought that would be the answer.
We're gonna see. I mean, generally bodily injury is not covered by E&O, right? And so I'm not exactly sure. And this is again, I'll be able to answer that question in a couple of years, because what we might see is a claim for somebody becoming ill because a broker exposed at home or individuals to the disease. Somebody became ill, somebody sued the broker tries to file an errors and omissions claim, errors and omissions provider or insurance company denies the claim, says we're not covering it, and then there's some litigation that ensues between the insurance company and the broker or brokerage firm, and ultimately a judge is going to decide this should have been covered or this shouldn't have been covered. My suspicion is probably not, very candidly, because I think this falls into the sort of the bodily injury or it's not just, it's typically an excluded component of things. I can tell you that illness generally, from a brokerage standpoint, is not going to fall into the errors and omissions realm. But again, this is such a unique issue. And the other thing is it's also so unique because it's so pervasive on our society. And so it is clearly within a broker's standard of care to be advising their buyers and or sellers. And that's kind of part of what this advisory is hopefully going to be helping you guys with. It's clearly something that is so squarely within the standard of care of a broker that they are going to have to be making sure that their clients are aware of the basic risks and considerations that they ought to be thinking of during the course of the pandemic. So I don't know. Talk to me in a couple of years and I'll have a much better answer for you.
Okay, I just want to circle back really quick on our question previously regarding if it's your listing, and is the listing broker required to provide masks or the PPE, or I know common sense says one thing, but are you seeing anything in regards to that?
Well, I can talk to you about, and I'll be honest, I'm not totally up to speed on what specific Eagle County and or any of your local municipalities have going with regard to limitations. What in terms of anything over and above the state's safer at home policy, the governor's policy that's currently in place. And so I'll speak to the governor's policy.
Just so you know, Scott, we are the same as the safer at home, just so that helps you a little bit.
That helps a lot.
Following.
Yeah, so under the safer at home policy, one of the things that is in, how about this? How about if I kind of run through that policy real quickly and I'll address the question in a broader sense there. Or, I mean, I could, under Appendix B of the public health order, which is the CDPHE, the Colorado Department of Public Health and Environment. So let me just clarify, the governor's executive order, safer at home, it's pretty, it doesn't say much. It's about 2 pages long or 3 pages long, and it basically directs the CDPHE to promulgate a policy, or to promulgate a public health order. And so that's what the CDPHE did, is it created this public health order that is now what is in effect. And there's 2 operative sections in that public health order. One is the definition of a field service worker, which is what you guys all are. And it specifically refers to real estate, but it's other industries, other professionals that don't necessarily work in an office. They work out and about in the community, like you guys do. And so under the definition of a field service worker, there's an expectation that, particularly for real estate, that between showings, which are permitted now in the state, unless there's other local jurisdictional limitations, in between each showing, a property has to be, disinfected, sanitized in between each showing. And that's under the definition of field service worker. And then it also refers to complying with all of the expectations under Appendix B. And so Appendix B has a laundry list of items that it refers to employers that, and in this case, that would be an employing broker or a brokerage firm. A laundry list of items that employers need to ensure when it comes to their field service workers engaging in their field service work. And so if we look at Appendix B, one of the things that it says, let me just get to the section here so that I can speak specifically to it. If you guys haven't seen the order, it's on a Legal Bites that I did, I think the last one. There's a link to it. And there's, like I say, there's 2 areas to look at. One is at the very bottom of page 5 for a quick paragraph definition of field service worker. And then Appendix B, which is, begins at page 18. And that's where really the meat of everything is. So one of the things that it says is employers must implement the following measures regarding employees to minimize disease transmission. Provide gloves and masks for any customer interactions or work being done in third-party home or office spaces. So let me say this, don't get caught up in the distinction between employee and independent contractor, right? So I know most of you guys in your employment or within your brokerage firms, or if you're brokerage firm owners, you're not employers, at least among your agents, but for the purposes of the public health order and the expectations of the safer at home policy, you are. They're not, just because you have independent contractors doesn't mean that you're exempt from the expectations here. So what this technically says is that the employer, so the brokerage firm, is responsible for making sure and providing gloves, masks, and other provide gloves and masks for any customer interactions or work being done in third-party homes or office spaces. So I think a showing would be a buyer doing work in a third-party home or an office space. And so technically under this, I think it would say that the brokerage firm is responsible for making sure that two buyers or whoever's going into the house actually have that. I mean, I can just read you from the order what it says. That's my interpretation of it. I know that's not necessarily totally practical because the availability of gloves and masks are, as I sit here trying to figure out where my family's going to get toilet paper at some point in the next 2 days, because I think we're at that kind of at that point in our supply chain, in my house anyhow. I know that gloves and masks are of incredibly limited availability, so they're just not floating around everywhere. So I do think that what the expectation would be is that if you're a brokerage firm, broker owner, you need to have a current policy in place that makes sure your brokers comply with the Safer at Home order, and that's going to ensure that your brokers, specifically buyers agents, are requiring that their buyers are entering a home with gloves and masks on, providing them. It's what the order technically says, but whether or not that's practical, I'm not entirely sure. So anyhow, that's one of the specific qualifications that are currently required under your Safer at Home order.
Okay, so thank you. I appreciate that. Just to get through a couple of our other questions, and I see we've got some coming through on the chat. So if the public health order is a recommendation, how is it being enforced, and can it be enforced?
Well, first of all, it is a recommendation for individuals who take off your realtor hats. If you want to leave your house, you can leave your house. Unlike the stay-at-home order where you were, unless as a citizen, forget realtor, as a citizen of Colorado, if you wanted to leave your house, it had to be under the stay-at-home order under very limited specific instances. You're going to the doctor, you're going to provide care for a family member, you're going to the grocery store, things like that. So for the purposes of you being a citizen, it is a recommendation at this point. You're safer at home. And even it's a little bit nuanced when it comes to people that are of compromised health or have pre-existing conditions or of a certain age. It basically says that those people are supposed to continue staying at home. But for the rest of us, it's a recommendation. You're exactly right. But don't delineate between that as a recommendation for you as citizen versus you as realtor professional. Because you as realtor professional, it is an order. In other words, if you are going to be performing a business function as a realtor professional, then you have to comply. It is not a recommendation, it is a mandate, because there's a difference between you as Colorado citizen being able to stay in your house and you as Colorado citizen being, or you as Colorado realtor being able to go and provide your professional services. One is a recommendation, Colorado citizen. Two is Colorado realtor, it's an order. So don't misconceive those two distinctions in terms of how this is interpreted. If you're going to be doing business as a professional in business, specifically as a realtor in this case, then you have to comply with the requirements of a field service worker definition, and you have to comply with Appendix B. That part is an order. The last thing I'd say about this, and it's just a reminder, everything can change. In other words, if you guys all remember with the stay-at-home order where we started after Carr worked really, really hard to get real estate services or real estate transactions exempted from the stay-at-home order, it took one broker in the metro area one time of kicking a tenant out of the house so that they could show an investment property for a day, and that tenant complaining to the Attorney General saying, not so much, no more showings. And so similarly with this, if you guys aren't respectful of the parameters and expectations of the order, then we'll end up back where we were, and showings will go away and there won't even be any of that. And so that's the challenge with not being strictly adherent to the expectations for this period of time. And be clear, the order does go through, I think it's May 28th, 29th. It's the end of this month, basically, is what the Safer at Home order goes. And so whether it's extended or not, remains to be seen. We won't know that for a few more weeks. And obviously that's going to be all done based on the governor's office monitoring of, the pandemic and the, twists and turns that we're all encountering here. So anyhow, don't confuse it though. It is an order for the purposes of your business. It's a recommendation for the purposes of your, trips to the liquor store and the pot shop.
Good to know. So as far as how this is being enforced, is that, can you talk a little bit about that? And have you seen other boards, realtor boards, taking a stance one way or another, or the I guess, policing and accountability for this?
Sure. I mean, so enforcement could come from, enforcement of the state order has been through the Attorney General's office. So the cease and desist letters that have been generated by the AG's office under the stay-at-home order, and I know there have been some under the safer-at-home order, although not specifically to our industry, thankfully. The cease and desist letters have come from the Attorney General's office. And so that's the basis of the enforcement. And they've got broad power. I mean, the Attorney General's office is able to initiate a complaint, to prosecute a complaint, and to sort of hear that through. So and then you've got your local counties. And I know, different counties have a different perspective. And so some county sheriffs are very heavy-handed in sort of their enforcement of the expectations of the state order, and some maybe less so. And that just depends on the sort of, I don't know, the political leanings of the sheriff or maybe county commissioners or whoever. So, so that's what we'll call the AG and potentially the local county enforcement agencies, whether it's a public health office, whether it's a county sheriff, or whether it's a county commissioners, could potentially enforce it. And then you've got the regulatory stuff, which is the Division of Real Estate. So, and applies specifically to you guys. So and I know that I've spoken with Marcia Waters about this towards the last couple of weeks of the stay-at-home order. I think over the course of 1 week, she had mentioned that they had received 12 individual complaints about people violating that, the Division of Real Estate. And they opened investigations. I don't know about all 12, but I know that they opened a number of investigations into individual licensees who were not complying with the showing limitations, right? And so I think Marcia is, at least in listening or talking to her a little bit about it, I think their office is being pretty judicious in their sort of pursuit of these things, and they're sort of limiting any potential investigations to what I would consider to be the more egregious kind of fact patterns. But they have oversight as well, and so they could enforce a complaint against a licensee based on two areas that she specifically mentioned. Is one would be incompetency. So I used to know the rule number. I think it's 6. Well, it used to be E47. We changed all the rules, as many of you guys know, effective January 1st. And I've been so engrossed in COVID that I've lost even some of the new rules that I had my head around. But there was a competency rule. And so basically it would be incompetent for a licensee to be encouraging and providing certain activities that are sort of reckless or beyond what the state order would allow. And so it could be enforced by the division under a competency or incompetency investigation or complaint, and also under kind of a uniform duty or expectation of standard of care that you're not in the course of your business violating any laws. And these executive orders have the effect of law. And so those are the two ways that the division could approach a complaint for their enforcement of the order.
Perfect. A popular question, and I don't know if you'll know a lot about this, but if you could weigh in, because it is somewhat Eagle County specific, is that Eagle County has released their phase 1 plan to get the economy and business back up and running. And in that, they describe, and I guess we're considered, that other form of business, but that the question becomes, are we allowed to show property to other than local residents? So in that document, they define local residents are those persons who maintain or live in a home or local residence in Eagle County, in addition to persons living in counties of contiguous to Eagle County, where essential services and businesses are not readily available. So our question becomes, you know, if we have buyers coming from out of county, are we okay to show them? I think that we're in a situation where we have a lot of sellers that absolutely are in critical situations to sell. And so, you know, do we have some brokers that are willing to show out of county buyers? Do we have other brokers that are trying to adhere to the letter of the rule? And how does that play out?
Yeah, so I guess I think your Eagle County has limitations on allowing anybody to come in. So that's basically what I'm hearing. And I know you're not the only one. I know like San Miguel County, same thing. You can't have non-residents of the county can't enter Eagle County for the time being. Is that essentially the starting point of what you're asking?
I think so. I think that's what Eagle County is saying.
And so if that's your county's limitation, then so how do I say this? So I don't think you guys have a concern as an agent. I don't think that you guys have a concern about violating the rule, because if you're Eagle County residents and you're doing your business in Eagle County, then you're not breaking Eagle County's specific countywide limitation. In other words, you're allowed to be out and about in Eagle County because you're an Eagle County resident already. So I don't think, it's not as if you're going to get cited for violation of Eagle County's order. The problem is if a buyer is coming into Eagle County, then they are in violation of Eagle County's order because they've entered the county wrongly. This doesn't sound exactly right, but you get my point. In other words, by coming into the county as a non-resident, they are in violation of Eagle County's expectations. And so I could see, so first of all, I don't think you would have, you know, Eagle County Sheriff or Eagle County Commissioners or whoever is enforcing your county order, Eagle County Attorney maybe, whoever's enforcing that order, I don't think you have to be concerned that they're going to cite you or fine you as a broker. What could happen in terms of your liability would be that that somebody makes a complaint to the Division of Real Estate. And now we're back to what I discussed before in terms of, did it fall below your standard of care or your competency expectation if you as a broker are essentially encouraging or inviting or perpetuating a consumer, in this case a buyer, to enter into the county against what you know is the executive order. And so while I don't think you would have necessarily the, let's call it civil or potentially criminal liability associated with violating the order yourself, you could have potentially the regulatory liability as a licensee if somebody were to file a complaint with the Division of Real Estate and the Division of Real Estate said, you know, this is such egregious behavior, it fell below the standard of care that we would expect of our licensees, or it was incompetent, and so we're going to initiate a complaint against that licensee who did that. I think on the listing side, and I'm just kind of talking off the top of my head here, but I think on the listing side, I could argue you might have less exposure if you're the listing broker and you're just scheduling a tour. You're allowing a property that you have listed to be accessed by buyers. You're not necessarily qualifying where that buyer is coming from or what they're doing. But if you're a buyer's agent and let's say you're a Eagle County buyer's agent and you have a buyer from Denver and you're saying, yeah, come on up this weekend. We'll go look at some properties. We're all, clear to show. I think you could have some regulatory liability if somebody reported you. And that's the problem, is that, it's this sort of uneven playing field that your friends and colleagues in the marketplace are concerned about, because they're saying, well, wait a second, I'm adhering to the order, but I know they're scheduling showings with buyers from, outside of county, and it's your friends and colleagues that initiate the complaint potentially with the Division of Real Estate. And so the likelihood of a complaint is higher than, I think, normal in that regard. The other thing I'll say, because it's a good segue, or it's a good time to mention this, is there is no time I'm aware of in history where we have more nosy neighbors around I mean, everybody is at home. Now, you guys are a bit of a unique market because you're second home, sometimes in many places a second home market, but you've got a lot of primary residents as well. And they're all stuck at home in their house, staring out their windows, sitting on their front porches, paying attention to everything and everybody that's on their street. And so to the extent that, you are taking buyers into a listed property with a for sale sign in front of it, and nobody's wearing masks and gloves, and you've got, family and extended family, and everybody's standing in the front yard and kids are running around, there's a pretty good likelihood that a neighbor is going to be watching you and seeing that and going to be inspired to, either complain to your county sheriff or your county attorney or state AG's office or to the Division of Real Estate or whatever. So be aware of that and know that there's a lot of people that are paying attention to what you're doing right now, I think more than ever, just because of the nature of this pandemic. So somebody mentioned when I talked to him previously about this, that it's in Bewitched, there was a neighbor, Kravitz, I can't think of her first name, but the neighbor Kravitz, the little old lady next door was always, peeking out the window and checking out what was going on. And so you got a lot of those right now. So anyhow, be cautious.
So one of the questions that just came in regarding this topic was, Eagle County states you must not knowingly encourage non-local resident customers or prospective customers to travel to Eagle County to transact business. And I guess my take is it our responsibility to check their residence, or, how do we go about that? Or is it a situation where it's common sense? And like you said, as long as we're following the order.
Again, I think I would delineate between the listing broker and the buyer broker for the purpose of that question. So I'm looking, it looks like Jody threw up Eagle County states you must not knowingly encourage non-local resident customers or prospective customers to travel to Eagle County to transact business. So and you guys tell me if I'm wrong, but I think generally speaking on the listing side, if you're listing a property, and again, you guys are a unique market because you've got homes that are astronomically valued and you're very specific about qualifying potential buyers who are going to tour anyhow. So it may be a little bit unique in your market, but if you're a listing broker, in most cases that I can speak to, the listing broker is going to allow a showing to be set up by a buyer's agent. I mean, that's through the MLS or through whatever scheduling service you use or whatever. And I think it's not necessarily typical that a listing broker would go to the trouble to find out where's this buyer coming from, what are they doing, et cetera. And I don't think that necessarily needs to change for the purposes of this, but it's the buyer's agent. If you have buyers and hey, they're coming in from Texas, they're coming in from Denver, they're coming in from, Europe, wherever your buyers come from, which is a pretty big pool. I think it's important, again, within your standard of care as a licensed real estate broker, to inform your buyers that they, in arriving in Eagle County, will be violating that Eagle County order. And that's where you could have liability. I'm not saying you wouldn't have it as a listing broker if you knowingly are allowing showings to be scheduled with buyers that are from out of county or out of state, but I think the buyer's agent in every case is going to know where their buyers are coming from to come view the property. And so that's where absolutely I could see liability for a buyer's agent in that case.
Okay, great. Thanks. We'll try and answer a couple of the questions we've got in the chat. So the first one I saw come through was a rental management question. And it says, what are rental managers doing about renters not paying all or part of rent payments, eviction, etc.?
I mean, guys, it's tough to be a landlord right now. It just is. What are managers doing? I think managers are, at this point, I think you're acting at the instruction of your landlord or client. And so, you've got to make if you're a property manager, I think if you've got an in-state property owner, in-state client, they're more than likely very familiar with some of the specific state orders with regard to performing or not performing evictions and making demands for payment and everything else. And so in that case, maybe you're just, coordinating with your client in state to make sure that they understand or that they're paying attention to some of the statewide directives. If you have, as many of you probably do, out of state clients that you're managing properties for, they may not be as familiar. And I think you probably have some responsibility to make sure that they become familiar with what the limitations in the state of Colorado are with regard to a property owner in terms of enforcement of their normal rights and remedies under a traditional lease, because they're kind of out the door at this point. And Colorado is not unique to any other state. In other words, I think, throughout the country, we have seen, states do very much the same thing, because there's a lot of people who just frankly are incapable of paying their rent at this point in time. And what I've been telling property managers is your normal hammer, the stick that you normally have, which is your lease, to force a tenant into making payment or demanding, timely rent or posting a 10-day notice now. All of those things are out the door, because you don't have your stick anymore. Because guess what? I don't think any county court in the state, and so it's up to the counties with regard to whether they're handling even hearing evictions or FED matters right now. I don't think any county in the state is even hearing or scheduling FED matters in the state. And I think I'm virtually certain that there's no county sheriff's office in the country, or I'm sorry, in the state of Colorado, that are actually performing the eviction to begin with. And so while you can post all the notices you want, you can demand payment, and you can scream and throw a hissy fit on the front yard, the reality of it is, if the tenant's not going to pay rent or move, you don't have any stick to get them out. And so it's a terrible time to be a property owner. Now, I guess I can never imagine, months ago saying it's a terrible time to be a property owner in Eagle County, Colorado. And so fortunately, this is a very small, I think, narrow window where it's a terrible time to be a property owner in Eagle County, Colorado. But that's just the reality, because as a landlord, as a property manager, the stick that you normally have it doesn't exist anymore. So, but make sure your clients are aware. In-state clients, make sure they're aware if they're investor owners, they're paying attention. Most of them likely are anyhow, because they're concerned about the same things that you guys are. And if you're a property manager with out-of-state clients, you might want to kind of corral. There's been a couple of orders in the last 2 weeks, specifically in Colorado, with regard to evictions. And I think you might be able to find them on our COVID portal on CAR. If you haven't been there before, CAR's got a COVID portal on our main page, and we're just pushing all kinds of resources into that. So anyhow.
Okay, a couple more questions about listings and showings. And so I'll group them together. To clarify, is it mandatory or recommended to have your listing cleaned after every showing? And then I guess who does that? Or is it providing gloves, wipes, sanitizer, etc.? Does that suffice? And then the next one that ties in really close to that is, do you need to have a notice posted at the listing in regard to the measures being taken? Okay.
So mandatory to clean. And so I'll just read from the field services definition here. Real estate includes in-person real estate showings and marketing services, which must adhere to social distancing requirements with cleaning and disinfection between each showing, but may not hold open houses. So it's not a suggestion, it's a mandate. Between each showing, the property has to be cleaned and disinfected. Now, what cleaning and disinfection is it's sort of in the eye of the beholder. If you were to ask any of my 3 children what cleaning and disinfection is, it's a very different answer than what my wife might give as a cleaning and disinfection answer. And so I understand there's some ambiguity and gray area there. So I guess what I would tell you is to use responsibility and to make sure that, by reasonable standard, that surfaces that would be commonly touched or need to be touched are, wiped down, Clorox, whatever your process is. But it is not an elective thing. It's not a suggestion. It's a mandate. And then in terms of who does it, it's a little difficult. So both brokers are frankly, both brokers, buyer's agent and seller's agent, are field service workers. So they're both responsible for the same thing. I think in this case, the listing broker has what I would describe as sort of primary responsibility to ensure that that's done prior to showings. And what that's going to mean is you're not going to have back-to-back showings, 1 hour and then the next hour and then the next hour. I just don't think that's practical unless you're going to be, as a listing agent, sort of standing outside the door, letting the buyers leave and the agent leave, and then going in and doing your thing and trying to, kind of flip a showing around real quickly. Or unless you have very diligent and present sellers who are going to be, in or around the house between showings and are willing to sort of take that responsibility on themselves. So the responsibility is, it resides with the field service worker, which is both the buyer's agent and the seller's agent. But I think in the case of the listing agent, you've got more responsibility to ensure that it's done in some manner. So on an occupied property, I think you're going to be, as a listing agent, having a lot of these conversations with your seller. And in the advisories that I'm going to roll out here this week, there's a little discussion about, in the seller advisory, the seller ought to be, if they're occupying the property for their own health and safety, ought to be doing, making sure that they're disinfecting properly after showings. But if you can also ask the buyer, if you can put in the showing notes or put in the showing requirements, not that there's a showing requirements, but if you're a listing agent and you're working with a buyer's agent who is diligent and is going to actually do what they say they're going to do, you can work that out with the buyer's agent to say, hey, when you're done with the showing, will you please re-enter the property and wipe it down and do the disinfection thing? It's a matter of coordination and conversation. You guys, talk about, realtors cooperating. This is the ultimate, sort of opportunity for brokers to cooperate with each other. And so the buyer's agent could do it in that case on an occupied home. They could also maybe more appropriately do it on an unoccupied home. So it's a vacant property. You could make a request. The buyer's agent goes in, performs the showing, limits touching in as many ways by themselves and by other people, and then ends the showing, goes back in and does, the surface kind of wipe down and everything else that needs to take place. So, so the other thing I would just mention, because it's kind of in there, if you're a listing agent, to be making sure that, windows are open, lights are on, some cabinet doors are open, doors are open, so you can help eliminate the touching that is required by the buyer and the buyer's agent. You're going to be doing yourselves a lot of favors there. And so again, in the advisories that you're going to get here, there's a little section that basically suggests that, for sellers that they're leaving, if they're leaving their property, that they are leaving lights on, opening doors. A lot of the traditional sort of making a property look good prior to showing stuff, kind of pre-stage or staging kind of things you do before showing, but even more important because it's going to eliminate a lot of touching.
Great, thank you so much. So I know that we're somewhat limited on time here. We have about 7 minutes left. I don't see any new questions coming in unless Erica sees them coming in. We do have, it looks like a little over 50 people on this chat. And so I think we'll also take a couple minutes. The Vail Board of Realtors is in the process of rolling out a safe showing pledge that we're listing out what these different guidelines are and the benefits and why it's important to practice these guidelines and requirements so that A, we can get it out to all our brokers, and B, so that we can also get this out to the public so that the perception becomes that we are taking this very seriously and responsible. So for those of you guys on the call, look for an email coming from Erica. We encourage everybody to help spread the word about what the Safe Showing Pledge is. The team at the Vail Board of Realtors has done a fantastic job putting together graphics and stuff that we can use in marketing and social media. I know a number of the larger firms in the Valley, their leadership is standing behind this to take the pledge. I don't know if you want to jump in, Erica, and add anything more.
Yeah, so it ended up coming from the Eagle County Task Force that I was asked to chair. And we had a discussion of the neighbors being concerned about people showing property. So, we took it to, kind of talked about it and thought, well, why don't we put these guidelines out and share what all the extra steps that are being taken when it comes to cleaning, doing the extra cleaning with the property, wearing masks and things like that. So, we thought, well, it would be a great way to send this out to the public and have our members send it out to the public. So I think it hopefully will, it should be really well received and a good, public campaign. So.
Scott, if you're still with us, we did have one more question that we'll squeeze in, which is, for tracking purposes per the order, are we allowed to ask the listing broker if buyer broker or buyer has had the virus or come in contact with someone who has had it?
Good question. And the answer would be yes, absolutely. As long as you're asking everybody, this is a fair housing issue. If you're having a uniform policy and, you're not just singling out, certain categories of people, then you're absolutely asked. And I think it's absolutely a best practice to do that. And obviously if you're a buyer's agent, listen, you ought to be having the same conversation with all of your clients before you, meet them at properties and everything else to try and suppress this. So, one of the other things that the Appendix B refers to is contact. Let's see, where is this here? Maintain a detailed log of customer interactions to enable contact tracing if it becomes necessary. The log should include name, date, location of contact, as well as the contact's phone number, email address. So this is written for all field services, not just brokerage. And brokerage is a little bit different for you guys, because a buyer's agent isn't necessarily going to be giving the listing agent the buyer's names, phone numbers, email addresses, and all that stuff. That you guys are rightfully protective of your clients and their information. But as long as the buyer's agent's maintaining that information with regard to who they're showing properties to, and the listing agent obviously is maintaining a list and tracing any buyer's agents who have taken people through a property, then that contact tracing can certainly be put together in the event that it needs to be for the purposes of somebody that ultimately does become infected. And so, I would make sure that you guys are on the listing or on the buyer side. If somebody might be asking you for all of their information, and to the extent that you're comfortable or willing to provide that, provide it. But I don't think that is necessary. I think it's a matter of both parties independently making sure that they're keeping records, and then they're willing to cooperate and coordinate after if somebody does become infected. So do think about that. Before I close here, I'm just going to say this, guys, just to try and end on a positive note, because I try to be pretty positive about everything. And this has not been a terribly positive few months. But I will say this, that, over the last, for those of you who heard me speak, most of last year, one of my primary talking points was like the NAR antitrust lawsuits that are percolating at the federal level. And the basis of those lawsuits really challenge your commissions, the money you earn, the value you add to a transaction. And those are still out there. They're pending. They're moving forward, and we'll have years probably of those things hanging around, a lot longer than hopefully this disease hangs around. We've also got the advent of iBuyers and technology platforms and alternative brokerage models and all kinds of things that at its core are really challenging what you guys do, how much you make, how much you're paid, your commission structures, your percentages, all of that stuff. And at its core, challenging the value proposition that you bring to the table. And I spent a lot of time talking to you guys about that, and last year trying to really challenge you to all of you have a value proposition. You wouldn't be sitting here on this phone call wasting your time with this mug listening to me if you didn't have a value proposition. And so being able to articulate that sometimes is hard for people. But one of the benefits, and there's not a lot, but one of the benefits of this disease is going to be that your value proposition for years to come, the value proposition of a realtor, and your ability to think creatively about transactions, to keep your parties informed, to hold deals together, to create opportunities, all of those things are being highlighted at this moment in time more than ever for you brokers that are out there doing business. And so be thinking about those, at least in terms of the very limited positive aspects of this, the positive impact on your value proposition and your ability to articulate your value proposition for, like I say, years to come, well beyond the length of what I hope this disease ultimately is is going to be forever heightened. And every one of you guys that went into this, into this, this pandemic together, and all of you that are going to come out of it together, all of you guys will come out of it on the other side of this being much better brokers than you were going into it. And so be thinking about that as you're sort of, frustrated with everything. And I think we all are, and I don't know any industry that doesn't have their own independent frustrations, but there is some sort of limited silver linings that I'd encourage you guys to at least, help keep your chins up.
Great, thank you so much. And I think, just to add on to that, we're so fortunate that we're in an industry that can still work and thrive. And I believe we can thrive in this environment, because there are, many millions that unfortunately don't have the opportunities that we have. So Erica, do you have anything more to add for closing?
I do not.
Well, you guys, thank you so much. It's been a great turnout. And Scott, as always, thank you for your guidance and all the work that CAR has done at the state level, and keeping us in the forefront of this, and continuing to be able to do our business.
You bet, guys. Thanks for having me, and hope to see you guys all in person at some point. It's much more preferred, particularly going to your beautiful community, than it is doing this virtually. But we'll all be back together at some point soon. So thank you, guys.
Thanks, everyone.